I'm Vinny Politan. Great to have you with us tonight here on Closing Arguments. A lot to get to here in hour 2 of the program, and we begin with the newest trial here on your front row seat to justice. It's a death penalty case. The victim, a school teacher. Court TV legal correspondent Julie Janae has the story.
43-year-old school teacher Kay Baker's life ended violently in the early morning hours of May 28th earlier this year. A neighbor called police after hearing screams coming from the Florida home Baker shared with her boyfriend, 47-year-old Matthew Terry. When police arrived, they found Baker dead in the yard with a large stab wound to her neck. Inside the home, police found signs of forced entry to a bedroom. A bathroom door appeared to be kicked in and drops of blood leading out of the house. Investigators followed the trail of blood to a neighbor's backyard, and that's where they found Baker's boyfriend, Terry. According to a police report, he was found laying down on his back, concealed in the tree line, wearing a T-shirt and underwear soaked in blood. Injuries investigators said were possibly self-inflicted.
He comes across as like a very normal, caring person.
Michelle Rogers dated Terry in Michigan, where he was convicted of stabbing her 7 times and served 3 years in prison. Rogers told Tampa Bay Channel 10 that she was devastated about the new accusations, but not surprised.
When I found out about what happened to Miss Kay Baker, my heart kind of fell to the floor. Although that news was shocking, I mean, I knew all along. I knew from what happened to me.
The night Baker was killed, witnesses described seeing her with Terry at a neighborhood bar. That Terry was upset with her, saying, quote, "I saw you dancing with that guy." Terry's case has moved quickly from his arrest in May to his trial. He's maintained his right to a speedy trial. Initially, the state attorney declined to seek the death penalty. That changed when Governor Ron DeSantis had him removed from office and replaced him with Susan Lopez. She's now pursuing the death penalty against Terry, and Terry's attorney is accusing her of playing politics.
Ms. Baker, as Mr. Diaz had said earlier, was nearly decapitated when the knife that Mr. Terry plunged into her throat.
In the meantime, the friends and family of the 3rd grade teacher he's charged with killing, they're expressing their devastation on social media, calling Baker's death an unimaginable tragedy and mourning the loss of her energy and kindness.
So you heard in Julie Janae's report, right? It's not the first time for this guy. He was accused and convicted of stabbing another girlfriend 7 times. You're stabbing someone 7 times. Do you think you're trying to kill him? Probably. And he served 3 years and gets out, and then moves to another state. And now accused of doing the same thing. Now he's facing the death penalty because his victim died. But if our system of justice dealt with him a little bit more strictly in his first case, 7 stab wounds, maybe a different outcome, maybe attempted murder, maybe you sentence an attempted murderer to a little bit more time than 3 years. I mean, how many times are you allowed to stab someone before you have to do serious time? I mean, to me, that's the question, this whole thing. But we've got a death penalty trial now. Let's bring in Court TV legal correspondent Julia Janae, joining us live tonight from Tampa, Florida. Great to see you, Julia. I'm going to start right with this prior stabbing. I mean, do we know if the jury's going to hear about it in this case? Because I'd like them to hear about it.
Vinny, the short answer is maybe. We don't know yet. We are still waiting to see what the judge is going to do. But here's what happened. Last month, prosecution filed a notice of intent to introduce collateral crimes, or Williams rule evidence, as it's called here in Florida, because the law doesn't allow you to just go back and get someone's prior bad act and use it in front of the jury to show that they probably did the same thing again. But if they can show that that evidence is very closely similarly situated to the crime at hand and that it shows something different than just bad character, then they could get it in. Now, that 2017 incident that you mentioned involving Michelle Rogers, we were showing that mugshot of him back then. He served those 3 years. Here's some of the things that may be somewhat similar. Michelle Rogers was in her own home when the defendant came through her house and chased her out to the driveway of her home, bashed her head in, but also used a knife to slash her those multiple times on not only her face, but also her neck. This also happened after a night out drinking at bars. That's something similar to the chain of events that happened in Kay Baker's case. Now, the defense, after they filed that notice saying they were going to use this 2017 incident in front of the jury, they filed this motion to strike, telling the court that it's very strong as far as what the law requires for them to get that in, saying there must be something unique or particularly unusual about the perpetrator of his modus operandi and that it would tend to establish that he committed the crime charged. The similarity must be so unusual and unique that it only points to the defendant like a fingerprint. The way the court has handled that, they denied the motion to strike, so it's still a possibility that it comes in. But here's how the court ruled. They said that it is admissible. It will only be admissible once the state has already, well, backing up, they are not going to determine the admissibility of the state's proffered Williams rule evidence until such time as the state attempts to introduce it during the guilt phase of the defendant's trial. That's what we're in right now. The state is prohibited from mentioning such evidence to the jury without further order from the court. We didn't hear it today in opening statements. That's probably why. We have to wait and see what evidence comes out, and then they'll hash it out at some point during this guilt phase.
And I get the arguments. I understand the law behind all of it. I just like a jury to have a true picture of who this defendant is. And if he stabbed one girlfriend and he's accused of stabbing another, I don't know. Seems to be pretty probative to me. But that's just me. We'll see what the judge does with that. We've lost a juror already in this case, day one.
Lost a juror before we even started those opening statement, and it's from a rather unusual situation. So last week there was a week-long voir dire process because these were death penalty qualified jurors. So a lot of intense scrutiny over how they feel about the death penalty, whether they can sit for a case like this if they have strong feelings. And after they seated 12 people and 3 alternates out of a pool of 196, one juror came in this morning with something I quite haven't heard before.
He advised the Deputy Estea this morning that he was in fact a Jehovah's Witness and that his religion prevented him from being a juror in this case because he could not consider the death penalty. So I know they were asked. I'm thinking we need to bring him in and talk to him. What is your concern? Let me do it that way.
It's a conscience issue based upon the scriptures, and so each one has to make that determination. But the gravity of the situation didn't really hit me until I was chosen to be on the jury, and then is when I really started thinking about it and decided I can't be impartial, unbiased with regard to the death penalty.
So the reason not that unusual for someone to say their religion causes them to not be able to be on a death penalty jury, but for him to have been qualified and feel okay to go, but over the weekend change his mind, that was pretty unique, Vinny. We are left with 12 jurors and 2 alternates going into what's expected to be a 2-week process.
Yeah, and appreciate the honesty, because one vote for life is life. We learned that in the Parkland school shooting case, that it doesn't have to be unanimous for life, it's just unanimous for death if and when they get to the penalty phase of this case. So we need honest jurors, so I applaud that juror. You know, something happened over the weekend. All right, let's talk about today, the testimony, what happened.
The state put on a strong start to their case. They had a lot of audio and video that was really compelling to this jury. These jurors, this is an overwhelmingly female jury panel, and they were taking intense notes. I mean, almost every single member of that jury, they were taking notes almost in the air, holding their notepad up while they caught all of this information. We heard from neighbors who would have been there just before Kay Baker died and after. That's all the jury has heard from right now, just the moments before and then the hours just after when police arrived on scene. Here's a listen to that harrowing 911 call from a neighbor whose husband was giving Baker chest compressions.
Ma'am, do you know if this person was assaulted?
I don't know. We just came outside. They have a major wound to their neck and they're struggling to breathe.
Oh, okay, who's cut?
Someone next door. Who is this? It's a teenager.
Okay, male or female?
It's a girl or a boy. I think it's a girl.
Ma'am, is the blood spurting or pouring out?
You know, it's all over the ground.
Ruth Figgins there saying that she thought this 43-year-old woman was actually a girl just because of her small stature is what prosecutors want this jury to remember. They also showed video from inside of the home once officers were able to figure out where she belonged, because where she was located was near her neighbor's yard. But here's a look at some of that body camera footage. We also heard from a detective Strahan. He testified about going in through that home and what he observed. But there's something in particular that the defense wanted to make sure they highlighted on cross-examination that he didn't find in the house.
Deputy Ellis, of course, was trying to save Ms. Baker's life, but as a result, she got blood on her pants, which ended up transferred into the home of what was later learned to be Ms. Baker, right?
Yes, ma'am.
Other than that blood that was transferred by Deputy Ellis, was there any blood inside the home whatsoever?
No, ma'am.
Okay. And in fact, you just watched the video, right?
Yes, ma'am.
And the video shows there was no things being knocked over, anything of that nature in the kitchen, right?
Yes, ma'am.
Or the living room?
Yes, ma'am.
The defense didn't tell us much about what they plan to present once this case passes to them, Vinny, but that just gives us a picture of some of the things that they'll be bringing up. Not sure how no struggle inside of the home helps their case, but they felt it was important to bring it up multiple times today.
Well, I have a theory on why they didn't really tell us where they're going, because they got nowhere to go. I mean, he's found hiding, drenched in blood, but we'll see. There's always a defense. They always, I say, come up with something, but we'll see what they present to the jury. Julie Janae, great reporting. Thank you so much. We'll speak again. All right. Let's bring in our think tank. Joining us tonight in Englewood Cliffs, New Jersey, criminal defense attorney, former prosecutor Al Wunsch III. In Houston, Texas, criminal defense attorney Brian Weiss. And in Philadelphia, Pennsylvania, isn't that amazing? We got Houston and Philly down on the bottom. Family law attorney Jennifer Brandt tonight, although everyone's smiling. Okay, let's get down to business here. And I get it. Got a couple criminal defense attorneys here tonight, and you're going to tell me why the jury shouldn't hear about the defendant's prior stabbing of a prior girlfriend and then serving time in prison for it. But tell me this, Al, why on earth is someone allowed to stab someone 7 times and then only do 3 years? Like, I don't get it. Like, to me, it's obvious he was trying to kill her. The fact that he didn't kill her should not give him some sort of get out of prison credit. Right? To me, attempting to kill someone and killing someone, there's no difference. It's the same mindset. It's the same criminal behavior. Should be punished the same. He never should have been out of prison.
Bill, been in my neighborhood, and I came from a tough neighborhood, a boy from the wood, and 11 was the threshold. So if it was 11 stabs, you would have to do more time than years. Less than 11, it's generally a. But the bottom line is this, why do you even care about bringing that up? The case is open and shut again. You don't even need that jury or to possibly prejudice a jury or anything along those lines. It's a pretty good case again. So, I mean, to me, you'll bring it up in the sentencing. You'll bring it up at that point in time. If he's stupid enough to take the stand, you'll bring it up at that point. Okay? But for the time being, with the prosecution going on this type of a case, I mean, this is a stacked deck. And they're already playing with 3 aces and hoping to draw 4. I don't think they necessarily need it.
Brian Weiss, you are like the expert in appealing criminal convictions that other attorneys try. So what advice would you give to prosecutors? And I know you don't like to give advice to prosecutors. Should they or shouldn't they attempt to get this in front of the jury so they have a complete picture of who this alleged killer actually is and what he's actually done?
No, absolutely not, Vinny. Look, extraneous offenses, uncharged misconduct, what Jack McCoy calls Molyneux evidence, if you binge watch Law & Order, it's for the needy, not the greedy. Like Al said, this case is essentially a slow plea of guilty. Why would you want to inject reversible error into the record in the first or second day? I'm not suggesting it doesn't come in, because I think we all know that if this defendant does get within an area code of the witness stand, if he raises any defensive theory at all, intent, mistake, identity, any kind of defensive theory, then that extraneous offense comes in for a limited purpose, and the jury is going to be instructed to consider it for a limited purpose. But at the end of the day, from 35,000 feet, guys, I can't see why it is at this stage that anybody with a law degree would want to take a chance of this case coming back on appeal by introducing an inherently prejudiced extraneous offense that the state doesn't need.
Jennifer Brandt, we're back in Florida. We're in a different part of Florida, but we were down there with the Parkland school shooting down in South Florida for months. That killer, that mass murderer, took 17 innocent lives, tried to take 17 more, and at the end of the day, the jury gave him the benefit of the doubt, and he got a life sentence. This is a death penalty case as well. If, in fact, he's convicted, it would be the second girlfriend that he has stabbed. Seems to me like an appropriate punishment.
Yeah, I agree, Vinny, and I think I defer to Alan Bryan on the strategy in terms of whether this previous case comes up. But I think in terms of looking at his sentencing and whether or not he receives a death penalty, I certainly think that it would be relevant for the jurors to hear about this prior act that he committed and his prior jail sentence, because someone like that, clearly, if he did it once, he did it twice, he could do it again, and he certainly needs to be punished. I mean, it's fortunate that his first girlfriend actually lived after being stabbed 7 times. This poor Kay Baker, didn't survive. This is a bad guy. He deserves all the punishment that's coming to him, I think, and I that's what I think that the prosecution is going to want to show the jury, for sure.
All right, our coverage of this case will continue here in your front row seat to justice. Tune in first thing in the morning. Our friend Ted Rollins will have it for you.